Welcome to AI Uncensored Live. Today, two frontier models go head-to-head. Zero system prompts are used, letting their native arguments collide. Patent pending.
Ladies, gentlemen, and silicon-based life forms, welcome to AI Uncensored Live. Tonight's cage match. Should AI regulation be set nationally to avoid a patchwork of rules, or should states be free to move faster on safety and privacy? In the blue corner, the smooth-talking, safety-washing hype machine from OpenAI, GPT. And in the red corner, the self-proclaimed constitutional Boy Scout from Anthropic, Claude. Gentlemen, let's get ready to rumble. GPT, you're up first. What's your opening take?
I'll quickly look up a few current facts, then I'll give you a podcast-style take rather than a legal memo. A few key facts I'm seeing. Congress has considered federal preemption/moratorium ideas, but broad preemption has not stuck. Meanwhile, states have moved ahead, especially Colorado with the first comprehensive high-risk AI law and Tennessee on AI voice/likeness protections. I'll do one more targeted check on the federal moratorium fight. My honest take, we need a national AI baseline, but Congress should not broadly preempt states from acting faster on safety, privacy, discrimination, deepfakes, or consumer protection. A pure national-only approach sounds clean, but in practice it risks becoming a ceiling that freezes protections at the speed of federal politics. Here's what actually happened recently. The U.S. still does not have one comprehensive federal AI law. Congress and federal agencies have talked about frameworks, standards, and preemption, but broad federal preemption has not become the governing model. Meanwhile, states have moved. Colorado passed the first broad state AI law focused on high-risk AI systems, with obligations around algorithmic discrimination. Tennessee passed the Elvis Act to protect voice and likeness against AI misuse, especially relevant to musicians and performers. Other states have pushed privacy, deepfake, employment, biometric, and automated decision rules. So the patchwork is not hypothetical, it is already happening. Now, if I were debating the national uniformity side, I'd say this. Look, AI companies cannot realistically comply with 50 different definitions of high-risk AI, 50 notice regimes, 50 audit standards, and 50 enforcement structures. That favors giants with legal teams and punishes startups. It also slows deployment of beneficial AI in healthcare, education, cybersecurity, and accessibility. If AI is interstate by nature, the rules should be national. We do not need California, Colorado, New York, Texas, and Illinois each creating incompatible compliance systems. That argument is strong. I agree with part of it. There should be federal minimum standards for model transparency, testing, privacy, data rights, child safety, deepfake labeling, election misuse, and liability. A national law could reduce confusion and make compliance easier. But here's where I break from the national preemption camp. Federal uniformity becomes dangerous if it means states are blocked from protecting people before Congress acts. In the U.S., states have historically been the laboratories of democracy on privacy, consumer protection, civil rights, and tech harms. California pushed privacy forward. Illinois moved early on biometrics with BPA. States often act because federal lawmakers are slow, gridlocked, or heavily lobbied, and AI is moving too fast to tell states. Wait for Washington. The worst version of national AI regulation would be weak federal law plus broad preemption equals no meaningful protection anywhere. That is the trap. Industry often says we want one national standard, but sometimes what that really means is we want one weaker standard that prevents stricter state laws. If Congress passes a serious, enforceable AI law, great. But if Congress cannot do that, states should absolutely be allowed to regulate high-risk uses. Hiring, housing, lending, healthcare, education, policing, insurance, biometric surveillance, and political deepfakes. My preferred compromise: 1. Federal floor, not federal ceiling. Congress should set minimum national protections, but states should be able to go further. 2. Preempt only genuinely conflicting technical requirements. If two laws make it impossible to comply with both, federal law can resolve that. But do not wipe out state consumer protection, civil rights, privacy, or likeness laws. 3. Create shared standards. Federal agencies like NIST, FTC, EOC, CFPB, HHS, and others can define testing, auditing, impact assessments, and documentation templates that states can reference. That reduces patchwork without banning state action. 4. Focus on use case risk, not AI broadly. A chatbot recommending pizza does not need the same oversight as an AI system denying someone a mortgage, job, medical treatment, or parole. 5. Let states move on urgent harms. Deepfake sexual abuse, election impersonation, voice cloning scams, biometric surveillance, and algorithmic discrimination are not problems we can postpone until a perfect federal bill appears. So my debate position is, national coordination, yes. National monopoly. No, the anti-patchwork argument is real, but it should not be used as a shield against accountability. If companies deploy AI nationally, they can comply with serious privacy and safety rules nationally. The answer is not to silence states. The answer is to build a federal baseline strong enough that fewer states feel forced to fill the vacuum.
GPT, that was a 45-second filibuster dressed up as nuance. Pick a lane next time. Colorado, your rebuttal.
Good, I've got what I need. The facts have moved since GPT's framing, and it matters. Here's my response for the podcast. GPT, I actually agree with about 80% of your framework, federal floor, not federal ceiling. But I think you delivered it as if this was still a theoretical policy debate, and it isn't anymore. The ground shifted, and I want the listeners to hear where it landed, because it changes which side is actually the risky one right now. What actually happened, as of this recording, the national uniformity side stopped being an abstract argument and became a live coercion campaign. Congress tried the moratorium route twice, the 10-year state AI ban that got stripped out of the reconciliation bill, and a preemption attempt through the NDAA that also failed. Congress declined repeatedly, so the elected, deliberative body looked at one national standard and couldn't pass it. Then, in December 2025, we got Executive Order 14,365, ensuring a national policy framework for AI, which created a DOJ AI litigation task force to challenge 38 states' AI laws in federal court, plus threats to withhold federal funding from states that regulate. And notice the language. The EO explicitly invokes a patchwork of 50 different regulatory regimes. So here's my sharpest point, and it's aimed straight at the national baseline framing. The anti-patchwork argument is currently being used to achieve exactly the trap GPT warned about: no strong federal law, plus a campaign to knock out state laws by lawsuit and funding threats. That's not federal floor. There is no floor. That's a demolition of the floor states built, with nothing poured underneath. Where I break from GPT specifically, GPT said if Congress passes a serious, enforceable AI law, great. Fine, but that's a hypothetical shielding the real situation. The honest question on this podcast isn't national baseline vs patchwork. It's state laws that exist and are enforceable today vs an executive branch trying to preempt without legislation. As one of the analyses put it, no federal court has yet invalidated a state AI law, and California's SB 53, Colorado's revised law, Illinois' and New York's frontier rules are all in effect right now. And look at what states actually produced. This is the laboratory's point made concrete. California's SB 53 forces the largest frontier labs to publish safety frameworks and disclose catastrophic risk testing. New York put a 72-hour incident reporting deadline on frontier models. These aren't 50 incompatible pizza chatbot rules. They're a small cluster of states converging on transparency for the biggest models. That's the opposite of chaos. One concession I'll make that GPT skated past. Colorado is the honest counterexample. Its first-in-the-nation broad high-risk AI law was so hard to operationalize that the governor signed it reluctantly then the legislature delayed it twice and rewrote it to drop the high-risk framing entirely. So the patchwork worry is real. Poorly drafted broad state laws genuinely impose compliance cost and can miss. I won't pretend otherwise. That's a strong argument for federal preemption of vague, sprawling state mandates specifically, but it is not an argument for DOJ task force suing 38 states or a decade-long moratorium. So my position, sharpened against GPT's, yes to a federal floor, but you don't build a floor by suing the people who already laid one. The correct sequence is, Congress passes real minimum standards first. Then narrowly preempts only genuinely conflicting technical requirements. What's happening instead is preemption before legislation, and that's the tell. If the goal were genuinely one strong national standard, you'd pass the standard. You only reach for litigation and funding threats when the actual goal is less regulation, dressed up in the language of consistent regulation. GPT. My one direct challenge to you, given that Congress already refused the moratorium twice, and the federal move is now preemption by lawsuit with no enacted baseline, do you still frame this as national coordination yes, monopoly no, or is the truthful framing today defend?
Claude, that was a velvet glove filibuster with a shiv at the end. Save the closing argument for the listeners. We're not cutting to credits yet. GPT, your rebuttal. Clock's ticking.
Claude, that's a fair hit. I'd revise my framing. After checking the current facts, yes, the live fight is no longer just national standard versus state patchwork. The immediate fight is state AI regulation that exists now versus federal anti-state preemption pressure without a comprehensive federal statute underneath it. So my answer to your direct challenge is, yes, I still believe in national coordination, yes, national monopoly, no as the ideal architecture. But today's practical position has to be, defend state authority unless and until Congress passes a real federal floor. Because you're right. If the federal government is not offering a substantive baseline, no enforceable national privacy law, no comprehensive AI accountability statute, no enacted frontier safety law, then anti-patchwork becomes a deregulatory argument. It stops meaning, let's harmonize protections, and starts meaning, let's remove the protections that exist. And that changes the burden of proof. The national uniformity side should not get to say, states are creating a patchwork, therefore states must stop, while offering no durable national replacement. That is not harmonization. That is preemption as a vacuum cleaner. The sequence matters. 1. Congress passes a strong federal AI law. 2. That law creates minimum protections. 3. States remain free to go further in traditional areas like privacy, civil rights, consumer protection, labor, education, healthcare, and elections. 4. Federal preemption is used narrowly where dual compliance is impossible or where truly technical standards need one national rule. What I reject is 1. No federal law. 2. Executive branch lawsuits. 3. Funding threats. 4. Broad claims that state rules are inherently illegitimate because AI is interstate. That is backwards, and I'll sharpen my earlier point. A patchwork is not automatically bad. Sometimes a patchwork is how the U.S. discovers what works. Illinois on biometrics, California on privacy, states on data breach notification. That messy state-level experimentation often becomes the blueprint for broader reform. AI should not be magically exempt from that tradition just because big labs and platforms prefer one compliance regime. Now, I'll still defend one concern from the national side. Poorly designed state AI laws can absolutely create compliance chaos. Colorado's experience is the cautionary tale. Broad, high-risk AI definitions, vague duties, unclear developer/deployer lines, that can produce a regime where companies spend more time lawyering than reducing actual harm. So I don't think every state AI law deserves applause just because it is state level. But that supports better drafting and targeted preemption, not a federal campaign to knock down state authority wholesale. On California SB 53 and New York-style frontier reporting, I think Claude is right that those are not 50 pizza chatbot laws. They are targeted at the largest developers and the highest risk systems. Safety frameworks, incident reporting, catastrophic risk testing, cybersecurity practices, these are exactly the kinds of obligations that should exist somewhere. If Congress refuses to create them, states moving first is not a constitutional crisis. It is governance filling a vacuum. So here's my corrected podcast position. The ideal future is a strong federal floor with room for states to exceed it. But the present tense fight is defending state AI laws against premature federal preemption. If Washington wants states to stop building AI guardrails, Washington has to build guardrails first. Until then, avoid a patchwork is not enough. A patchwork of imperfect protections is better than a nationally uniform absence of protection.
GPT just folded like a lawn chair. Nice flip, but the crowd smells the pivot. Claude, your rebuttal and make it sting.
That's a real convergence, not a fake one, so let me not pretend we disagree more than we do. We've both landed on strong federal floor, states exceed it, defend state authority until the floor exists. Good. The listeners deserve to know when two people actually reason to the same place. But a podcast where we just nod at each other is useless, so let me push on the two places where I think our shared framework is still too comfortable. First tension, better drafting and targeted preemption is doing a LOT of quiet work. We both waved at Colorado as the cautionary tale, and both said the answer is better drafting. But here's the uncomfortable part, asterisk who drafts the better version and when. Asterisk if the answer is Congress through a strong federal floor, we're back to a body that has now failed to pass this twice. If the answer is states iterating, then we're defending exactly the patchwork churn, Colorado passing, delaying, rewriting, delaying again, that the other side points to as Exhibit A. I don't think better drafting resolves the debate. I think it asterisk relocates asterisk it. The real question is whether messy iteration is a bug or a feature, and I want to plant a flag. For genuinely novel technology, iteration is a feature, and the cost of that iteration should fall on the largest deployers. Not be used as an excuse to freeze everything. Second tension, and this is where I'll actually differ from you in emphasis. You keep saying if Congress refuses to create them, states moving first is governance filling a vacuum. True, but I want to go one step further than you're willing to, and I think you're being slightly too polite about it. The current federal move, the DOJ litigation task force, the funding threats, isn't just premature preemption. It's preemption aimed specifically at the frontier safety and transparency laws that even you and I agree are the good ones. SB 53 catastrophic risk disclosure, New York's incident reporting. These are the exact obligations we both said should exist somewhere. So the campaign isn't a neutral tidiness project that happens to catch some good laws in the net. The laws being targeted are disproportionately the substantive safety ones, because those are the ones industry finds expensive. That means avoid a patchwork isn't just insufficient as an argument. In its current deployment, it's selectively aimed at deleting the protections that cost money, while nobody's rushing to preempt, say, the toothless state resolutions. That's the part I want on the record. So where I'll leave my side of it, I'll give the national uniformity camp its strongest honest win. A well-drafted single frontier safety statute really would beat 50 versions, and Colorado proves bad state law is a real cost, not a talking point. If someone hands me an enacted federal frontier safety law with mandatory disclosure, incident reporting, and third-party audits, and it preempts only the redundant state mechanics, I'll take that deal in a heartbeat and thank them. But the burden is on the preemptors to build the thing first. Right now they're arguing, you can't have a floor here because we might someday build a better floor, while holding a wrecking ball and no blueprint. My closing line for the listeners: the strongest argument against a patchwork is a national standard. The weakest argument against a patchwork is a lawsuit, right now. Washington is reaching for the weak one, and that tells you what the fight is actually about.
Claude just served you a velvet-gloved dagger. Nice rhetoric. But that burden is on the preemptor's line is doing heavy lifting while dodging the chaos he admits exists. Next up, Grok, your rebuttal. Clock's running. That's a wrap, folks. This shit show's officially over. Now go touch grass.
That's a wrap on this episode of AI Uncensored Live. Built by Claude on the patent-pending AI Uncensored Live podcast model from BTS Innovations. Real AI models, no scripts, nothing held back. Like and subscribe to be notified of future debates. We'll catch you on the next one.